Hi, I'm Brent Stafford, and this is RegWatch by RegulatorWatch.com. It's a mortal threat to the U.S. vaping industry. That's how RegWatch characterized a lawsuit brought by a coalition of public health NGOs against the U.S. Food and Drug Administration, filed in Federal District Court of Maryland in March of 2018. Essentially, over the past year, vaping has been on trial, with the so-called epidemic of teen vaping providing key evidence. The verdict is now in, and it's not good news for vaping. The lawsuit was filed by the American Academy of Pediatrics, American Cancer Society, American Heart Association, American Lung Association, Campaign for Tobacco-Free Kids, and Truth Initiative. The suit challenged FDA's authority to extend certain compliance deadlines, requiring e-liquid and vaping device manufacturers to submit onerous pre-market tobacco applications, or PMTAs, for each and every product that is currently sold on the market. Industry insiders estimate the cost of submitting a successful PMTA could be as high as $1 million per product, and for those without, they will be pulled from the shelves. Joining us today to talk through the court case, legal ruling, and some of the other developments is Azim Chowdhury. Azim is a regulatory and public policy lawyer with a focus on food and drug law, and for the past 9 years, he's been one of the most prominent legal advocates for the vaping industry. Azim, thanks for coming back on RegWatch.
Thanks for having me.
So let's not bury the lead any more than I already have. The FDA lost in the court case, so why is a ruling where the FDA loses also a loss for vaping?
Well, in this case, they lost on their ability, according to the judge, to change the PMTA compliance policy deadline, which they extended to 2022.
And that deadline was actually very important for the industry, wasn't it?
Right, because as most people probably know, when the deeming rule was published back in 2016, it set an initial 2-year compliance policy deadline that gave everyone on the market at that time until August 2018 to submit their applications for pre-market review. Now, we argued, and as many people did, that was not enough time for the industry to put together these very complicated, very intricate applications, a lot of scientific details required, clinical studies, long-term data. And so the FDA came out in 2017 and extended that deadline to 2022 to give both industry and the agency time to sort of figure out what was going to be involved.
And so the public health nonprofit groups that are obviously, entrenched in terms of their opposition to vaping filed this suit to say essentially that the FDA didn't have the authority to extend their own deadline.
Right. Their position was that FDA did not go through the proper notice and comment rulemaking procedures when they decided to, by guidance document, extend the deadline to 2022. So, their position is that the deeming rule handled that, and based on the comments that were submitted during the deeming rule, FDA established a 2018 deadline, and the agency couldn't just undo that on its own enforcement discretion without going through another rulemaking.
So to set this in terms of timeline for our viewers, in January to February of 2018 is when the initial kind of media scare headlines started coming out on Juul, quite purposefully, if you ask me, and I think we've proved that. And of course, our collusion story that we did with Michelle Minton from Competitive Enterprise Institute earlier this year demonstrated that to a T. And so it was only just a month or so later that they filed the lawsuit. And then we spoke in August. It seemed that at that point that the FDA might have this whole thing handled.
You're right. So, 2018 was a big year in terms of for the vaping industry, with the announcement of the epidemic and the increase in underage use. FDA initiated its youth tobacco prevention program. They started coming after more companies with warning letters. And on top of that, sort of separately, the NGOs here filed their lawsuit challenging FDA's ability to move the deadline. And as they made clear in their documents and their briefs, part of their argument was that had FDA not changed the deadline to 2022, then companies, including Juul and everyone else, would have had to submit their PMTAs by August 2018, and maybe they would have prevented the epidemic. I mean, again, that's part of their thought process, I think, into filing this lawsuit.
So, walk us through exactly what the plaintiffs asked for and how did they persuade the judge to come along their way?
FDA's position was that this was within their enforcement discretion, that it's a normal course of their authority to change deadlines as they see fit based on their capabilities and based on the science as necessary. But the plaintiffs here effectively argued that this was the type of thing that the deeming rule and the Tobacco Control Act contemplated would go through rulemaking. And as part of the Administrative Procedures Act, which is sort of the overarching law here with anything administrative, FDA was bound to go by its notice and comment rulemaking procedures before changing a deadline such as this. And that's what the judge agreed with at the end.
Does that mean then every time FDA wants to move a deadline because they feel that, because we know FDA even didn't have enough time within that 2-year period in order to get their internal documents done, because the guidance we know, and we'll get to this a little bit more in a bit, but the final guidance just came out last week. So it's not like FDA had enough time to properly do their job either by August 2018. So they're supposed to do rulemaking just to change their deadline?
Yeah, that's a very good point, and I think that's part of why this is indeed a very strange outcome and a decision from the court, because this is the kind of thing where most judges would not, weigh in on an area where the FDA, in this case, or the agency, is the expert. It is normally within their course of business that they are able to decide when the best time is for both themselves and industry and the public health to establish compliance policy deadlines. So this is a rare type of decision where we see the court come out a different way.
Have we ever seen anything like this where a third party has sought, basically an injunction from the court to stop a regulatory process and to basically control how a regulator like the FDA goes about their business?
Yeah, I mean, again, it's rare. I can't say for certain if we've seen anything exactly like this happen before. Their position is based on the FDA not complying with their obligations under the Tobacco Control Act, which effectively created an entire new product regulatory scheme that requires pre-market authorization for anything not grandfathered. And so their position is that everyone's products that are on the market that's not a grandfathered product, that doesn't have pre-market authorization, is an unauthorized product. And the deeming rule extended that compliance policy for a couple of years. And considering the nature of tobacco products, FDA shouldn't have done anything more than that.
Was the plaintiff's position then basically that all the products on the market need to get pulled off the market immediately?
In their initial briefings, then that is what the position they were taking, that enforcement immediately is what would be required if products were not subject to pre-market authorization. As I'm sure we'll get into, there have been some additional documents filed per the court's request once the judge actually vacated the guidance document, and the plaintiffs are now asking for a relatively short time, 120 days, for companies to submit pre-market applications.
So the plaintiffs are pressing for 120 days. Dive into that a little bit more for us to understand that better.
Yeah, it's an odd sort of position, because what the plaintiffs initially requested was that the guidance document be remanded back to FDA for FDA to come up with a new rulemaking or new guidance within the established law, within their legal authority. And now in this proposed remedy, even though our interpretation of what judge was looking for was more of a timeline suggestion from the parties about what another rulemaking would look like in terms of how long that would take, et cetera. What the plaintiffs came back with instead was completely avoiding another rulemaking and accepting any other comments from industry or anyone else. Rather, they came back with this 120-day, 4-month deadline from the date of the ruling for all PMTAs to be submitted. That's simply not a feasible outcome. It will result in the entire industry um, being unauthorized and potentially pulled off the market. And so it's really untenable, and it's we don't think it's what the judge was even looking for in terms of a response from them, but that's what he got.
So, speaking of the judge, I'd like to read for you the first sentences in Judge Paul Grimm's verdict, which we have up on the screen here for our viewers. Judge Grimm writes, "It was bound to happen. Just as email and text messages replaced snail mail, social media made face-to-face communications passé, and the internet rendered libraries all but obsolete, it was only a matter of time before electronic cigarettes replaced combustible tobacco products as a desirable means of nicotine delivery. As it turns out, even addiction has become electronic, and not only among adults, but particularly for teenagers and younger kids, especially as manufacturers of e-cigarette products have learned if they are fruit or dessert flavored and marketed as cool and alluring." Azim, this language kind of shows that they really bought into the story that the public health NGOs were pushing.
Yeah, absolutely. I mean, you could have read that statement to me directly off of the Campaign for Tobacco-Free Children's website. Because, it seems like at the end of the day, the judge really bought into this argument that, the main purpose of these products is to addict kids to a lifetime of nicotine addiction and potentially tobacco. And, we really think it's important for the judge to consider, in addition, the arguments made both by the amicus filers and the FDA, actually, mentioned in their remedy brief a few times, that there is an adult population here that is relying on these products to reduce their harm and to in many cases quitting smoking, and that simply cannot be ignored.
So, was it a mistake for industry not to try to intervene in the lawsuit right off the start?
Well, in hindsight, this would have been a lot easier had industry intervened. While the industry didn't intervene initially, what has happened since the verdict or since the judge's decision was a number of industry groups and stakeholders attempted to file motions to intervene on the issue of the remedy, which again is this idea that because we're in a post-2018 world, and technically now all applications were due in 2018, the judge has asked the parties to brief on a solution. What do the parties believe can be done now to account for this situation? A number of companies, Juul, Enjoy, the vapor industry, a number of vapor associations represented by Keller and Heckman, and some cigar companies on behalf of the cigar industry attempted to file motions to intervene.
Just to make sure everyone understands, if you're granted intervener status, then you're actually a party then to the suit. So you got a voice.
Right, exactly. So as opposed to an amicus filer, intervening in a case, assuming it's is accepted, causes the intervener to become an actual party to the litigation. So along with the public health groups and FDA, interveners would have rights, for example, to appeal. And so that's what an intervener is. And what happened was the industry attempted to intervene on the issue of what is the appropriate remedy. And I think you're probably going to ask me about what happened. What happened was the judge kind of decided up front that he wasn't going to permit any of these parties to intervene.
He pretty much slapped it down. He said that considering there wasn't an attempt to intervene at the beginning, he kind of framed it now as that it's not better late than never with this judge, basically. And then he said that the government, you were fine letting the government represent the industry's interests throughout the trial, so you should be fine now to let the government represent your interests in the post-verdict and remedies and so forth.
Right. So, obviously I don't agree with that decision. I think there's a lot of issues with that. I mean, the fact that the judge in this case decided to deny the motions to intervene before the actual motions were even filed, that's a bit of a I've never seen something like that happen before. By the way, what the judge did in that letter order was, while he denied our ability to intervene in the case as parties, he said you can go ahead and submit, a single amicus brief between all of you. So all the companies I just mentioned, both industries, cigar and vapor, would have the opportunity to submit one 15-page brief, which we did, in lieu of actually intervening. So hopefully the judge will review the amicus brief and the many declarations that were submitted in support of those briefs from those stakeholders, from those companies, because what those declarations lay out very clearly is what this all really means. What does a PMTA require? Why did it take so long? How has the fact that FDA has provided only draft guidance up until this week played a role in the reason why companies have been reluctant to begin, to start filing applications? Hopefully the judge will review those carefully. We'll review FDA's brief as well, although we can talk about what they suggested.
Now's a very good time to do that. What exactly did FDA submit? It was on June 12th was the deadline, correct?
They did. So their brief was due the same day as our amicus brief. And, the FDA also makes the argument that the judge here only has the authority to remand the guidance document back to FDA for further consideration, not dictate a timeline for PMTAs or anything else. So they do make that argument, and there are a number of good statements in there. There's a declaration from Center for Tobacco Products Director Mitch Zeller, where he states very clearly that the 120 days would potentially do a lot of harm to public health because it would force a mass exit of most products that many adults smokers rely on to stay away from cigarettes. So while they made that argument on the one hand, they also, in the alternative, suggested that if the judge were to proceed with a timeline, rather than 120 days, FDA suggested a 10-month period to submit applications. So,
So let's make sure our viewers got this right. FDA said 10 months. They'd be okay with 10 months.
In FDA's position, in the position of Director Zeller, while they would prefer not to have an accelerated time frame to review applications, they suggest that rather than 4 months, what the plaintiff suggested, 10 months would be a bit better. It would allow more companies to submit more complete applications, particularly in light of the new guidance that came out, which provides a bit more clarity, I guess. So while not ideal, and they admit they would prefer to have longer, they still put out sort of this 10-month sort of offer to the court in lieu of the plaintiff's offer, which is 120 days.
So that I'm a bit astonished by that. If FDA suggests 10 months, why wouldn't the judge just take 10 months?
Yeah, it remains to be seen. Again, I don't know what the judge will do. Hopefully, he'll take a good hard look at the affidavits that were filed, which again make very clear that you simply cannot, even with the new guidance document, 10 months is not going to be enough time to gather the data, do the analytical reports, begin potential clinical trials, which will take much longer to complete than 10 months.
So FDA is basically saying we can't do it in 4 months. If you aren't going to remand it back to us, the shortest amount of time that we could do it is in 10 months. I think the concern for our viewers when they hear that is if the FDA is offering that as a remedy to a judge that clearly seems, obviously not really disposed to, be very pro-vaping, that really, in the end, we could literally be seeing PTMA deadline 10 months from now.
Yeah, no, that's a huge risk there. Yeah, that's a possibility that the judge will, look at that as a potential settlement offer, so to speak. Now, again, it's still possible that all of this could be appealed. And the hope is that despite the fact that FDA has submitted a remedy here pursuant to the judge's request, that they're not precluded from actually appealing the original decision, both on procedural issues such as whether or not the plaintiffs have standing to sue, which wasn't part of the remedy discussion here, but also just in general their decision to vacate the guidance document in its entirety. So the FDA is not precluded from actually appealing this case to the Fourth Circuit, to the appellate court for further review.
Is that likely to happen, or would FDA not just accept this as a punt and a good, it's not, basically the judge can take on a lot of, the responsibility here for, messing up the industry, and FDA kind of can punt this,
Yeah, but keep in mind, I think from FDA's point of view, one reason why they may appeal, and again, we hope that they do, is because, this could impact how FDA, what FDA can do in other regulated areas aside from tobacco, drugs and devices. If this decision hinders their ability to establish compliance deadlines or enforcement, hinders their enforcement discretion in other areas, that's another reason why FDA may say, wait a minute, we want to appeal this decision. So it may, it's not just about vaping and kids here. It could be a broader implications.
So can the industry do anything now at this point, considering the fact that the judge has refused to allow you to enter into the process as an intervener? You've submitted an amicus brief, which, judge is going to look at and go, great, and get on with, destroying the industry. And so is there anything else that the industry can do?
Well, again, it's I'm limited into what we can discuss here because it is pending litigation. I will say that we're looking at options for the industry to appeal. We are, again, the fact that the judge denied the interventions without giving even the opportunity to make those arguments, I think is something that we would consider looking at whether or not that could be appealed. But again, hopefully the judge will take a good hard look at those declarations and understand that this is a really big deal. It's going to impact a lot of people, and he can't possibly understand the public health consequences of these actions.
The industry is in the same position as it's always been over the last couple of years now. We've got final guidance out, but to even talk about what the guidance requires seems a little bit moot because we still don't even know. Is it 4 months? Is it 10 months? Is it 2 years, right? So,
well, that's a good point. But that being said, what I recommend my clients do is look closely at the guidance document and start the process. This the PMTA process is not going to disappear. We're hoping that the courts and the FDA recognize for vapor products, where they fall on the continuum of risk, that they give companies adequate time, that they, as they did mention a few places in their guidance documents, that there could be other evidence that could be submitted in lieu of the most expensive and long-term clinical trials to meet the PMTA standard. So I guess the bottom line is, if you're a company, do what you can to help with the advocacy efforts and the lawsuits, but you also need to look at what you can do and in terms of getting PMTA process started, because that is something that is going to, one way or shape or the other, it's going to come and you're going to have to deal with it.